name is Briony Driscoll, and I'm a New York barred corporate lawyer at a firm called Morris Cohen. And most importantly, I'm a SheFi member. I actually took the SheFi course 2 years ago, and at that time was just curious about DeFi and had done some reading about how the SEC was regulating tokens and the exchanges. And so I was curious to learn more, and I learned a ton through Maggie's course. And I was also connected with this wonderful community. So thank you, Maggie, for that. So what do I do in my day-to-day? I mostly focus on corporate transactions like equity financings, which are securities offerings, and mergers and acquisitions, which is like companies buying other companies. And I also work with the digital assets team at my law firm, which is headed up by Jason Gottlieb, who's one of the top securities crypto lawyers. So just note, I'm not going to do Q&A at the end, but I am around, so if you have any questions during the breaks, and I'm going to put up my contact details at the end of the slides as well, so you can telegram me or shoot me an email, and happy to help. So today we're going to dip our toes into the world of the SEC's regulation of tokens. Okay, so let's step back. Why do we care about the SEC? Who knows who the SEC is? So the SEC is the US Securities and Exchange Commission, and they have statutory authority to regulate tokens that fall within the definition of a security. So how do we know whether a token is a security? Does anyone know? Okay, only a couple of people, so you'll learn a lot. We applied the Howey Test. So the Howey Test is the test we use in the US to determine whether there is an investment contract, aka a security that is subject to disclosure requirements and needs to be registered with the SEC or qualified for an exemption. So who knows the elements of the Howey Test? Okay. So no one, it seems. So this is a good lesson, because everyone should know this. So the Howey Test is the test we use to do, so the elements of the Howey Test. So under the Howey Test, an investment contract exists when there is an investment of money in a common enterprise with a reasonable expectation of profits. And the expectation of profits is based upon the entrepreneurial or managerial efforts of others. So according to the SEC's application of this test, basically every token is a security. So part of the reason for that is the flexibility of these tests. So let's walk through each of these. Firstly, there has to be an investment of money. But the SEC says it doesn't have to be an investment of money. It can be an investment of time, attention. Basically, someone puts something into it, that test is met. Secondly, common enterprise. This is super broad. So if you have a token for a project, a network, that is your common enterprise. So these first two tests get met very quickly. Thirdly, expectation of profits. Do people buy something because they want the number to go up? Well, pretty much everyone buys something because they want the number to go up, right? And then with the fourth test, you look at the objective expectation. And it's an expectation of profits from the efforts of others. So as soon as there is a central entity that says anything at all about the token, project, product, or anything, for example, put out a rocket ship emoji, say we're doing this great thing, the SEC is going to say, okay, people are buying this token because they're going to do stuff. So this is how the SEC looks at the Howey Test. And except for XRP and the Ripple case, this is largely the way that the US courts have interpreted it too. So launching a token in the US does look like a securities issuance, at least for now. And if you do a securities issuance, as I noted earlier, you need to comply with the federal securities laws, which require that you either register the securities or you qualify for an exemption. So why doesn't everyone just do the full registration with the SEC? Well, that's like trying to put a square peg in a round hole. As for the exemptions, I'll come to these a bit later. And if you don't comply with the federal securities laws, well, the SEC can take all the money you received, impose a civil penalty, and award injunctive relief so you can never again issue a token that is a security. It's a bit scary. So before we turn to all this, let's step back a bit. Let's look at the history of the SEC's approach to tokens. Okay, so let's start. 1946, the US Supreme Court establishes the Howey Test. 2009, Satoshi creates Bitcoin. In 2013, we began to see the first legal actions in connection with crypto, mostly related to Ponzi schemes and money laundering. The ICO boom occurred in 2016, 2017, and extended through 2018, with thousands of ICOs, initial coin offerings. In 2017, the SEC concluded that DAO tokens are securities, and the then SEC chairman stated that basically all ICOs look like unregistered securities offerings. In 2018, the SEC, CFTC, and other US agencies began increasing their actions. At the end of 2018, we see SEC actions that are purely focused on securities violations. That is, ICOs being unregistered securities offerings with no allegations of fraud. So these are bona fide companies, no fraudulent promotion. In 2019, we start to see these types of cases hitting the district court. In 2021, we start to see the SEC pursue actions that don't involve an ICO, like in the library case. So looking at whether a token is a security outside of the ICO context, which it was found to be. With Chairman Gensler's appointment in 2021, we have increased scrutiny and enforcement actions. We also see a change in tactics. This is important to note. The SEC was massively overwhelmed going after token projects, so they redirected their attention to investigating exchanges. Probably because they cut off probably because the idea being that if they get the exchanges, then there's nowhere to trade tokens in any case. But that all gets unwound with DEXs, which we'll come to in a moment. So in 2023, we hear the court's ruling in Ripple. So although the judge ruled that institutional sales of XRP were sales of unregistered securities, buying off the exchange was not. So this is a different approach. So the court's reasoning was the buyer on an exchange doesn't know where the money is going, so they couldn't possibly be investing in Ripple. So the Howey test isn't met. So this sounds good, right? But a word of caution, this is a district court case, which other courts are free to disagree with, and we expect to be appealed. And we honestly won't even know where things are until these types of cases go up to the higher courts. So in 2023, the SEC focused on centralized exchanges, filing lawsuits against Coinbase, Binance, Kraken, and others. And in 2024, we've seen the SEC zoom in DeFi. In April, it issued a notice to Uniswap Labs, claiming the protocol is an unregistered securities exchange. Apart from establishing their case, there's another big issue for the SEC here: enforcement. Sure, they could shut down Uniswap Labs, but what about the protocol? Just last month, the SEC closed its investigation into Ethereum 2.0, likely because it is sufficiently decentralized. And what's next? Well, maybe we'll have a new SEC chairman in November. In any case, we hope that future SEC leadership will bring some positive solutions. So you're probably wondering, if the token meets the Howey test, that is, it's a security, how do you launch it in compliance with US securities laws? This is a good question, and one everyone is asking. When I directed this question to my colleague, Jason Gottlieb, who heads up our digital assets team, he said, stay the fuck out of the US, and don't say fuck. So we only have about 5 minutes left, so let's quickly explore why he said that. And just to note, we're going to focus on launching a token as a security in compliance with US federal securities laws. We're not even going to touch on how you could possibly try to launch a token that is not a security. That is for another day. And it's extremely difficult because of how the SEC approaches the Howey test, which I discussed earlier. So it's basically impossible in the US, which is important to understand. So we're looking at tokens as securities, and how do you do that under US federal securities laws? So here are some options. Okay, first up, full registration, which as I mentioned earlier is basically impossible for launching a token under the current requirements of the laws. Reg A+ offerings. Basically, this is like a mini IPO, and only like one company has tried to do this, cost them $2 million, was not successful. Right, so first two, not even options. Not going to touch on Reg CF. Let's look at Reg D offerings and entirely offshore offerings, because these are things that people are actually doing. So Reg D basically offers an exemption to full registration. Basically, if you make some disclosures, it allows you to sell to accredited investors, which is basically your rich friends. These investors are assumed to be sophisticated enough to do their own homework and have enough cash reserves to weather significant losses. However, there is a catch. Tokens issued under Reg D are restricted, meaning that there are prohibitions on their transfer. The buyer cannot sell for at least 1 year following purchase, and then once the year is up, to sell the token publicly, it has to be unrestricted in compliance with Rule 144. Which basically requires doing a bunch of disclosures, which no one is doing. So there have been a lot of these Reg D offerings with many restricted tokens dumped on DEXs when the year is up, when the holder thinks they're free to trade, but they're actually not. And the SEC has kind of addressed this, but kind of hasn't. So it's probably a bit of a ticking time bomb in crypto. So super difficult to unrestrict. What if instead of trying to unrestrict the token, we unsecurity the token? Unsecurity the whole thing. So that sounds interesting. And we have seen this before. Remember, nothing starts decentralized. Even Bitcoin, on day one, Satoshi issued it. So let's look at Ethereum. From what we know about the Howey test, it was likely a security to start with. The Ethereum Foundation initially launched Ether in 2014. And the SEC recently dropped its investigation into Ethereum 2.0. We actually don't know what the SEC was specifically looking at or why they dropped the investigation, but we can assume that they are no longer considering whether Ethereum is a security, probably because it is decentralized. So let's go back to Reg D. What if during that 1 year holding period, they decentralized the token so that the token is no longer a security, so that no one has an expectation of profits from the efforts of others, going back to the Howey test. This is effectively what happened with Ethereum. If you buy ETH today, are you doing so because the Ethereum Foundation is doing something? No. So this is good in theory, but it's not easy to do, and we don't know if this would hold up in court. So the other route people are taking under the federal securities laws is to do an entirely offshore offering. Basically, the federal security laws don't apply extraterritorial, except with respect to fraud. So one solution is, as my colleague Jason said, to stay out of the US. And it's tough to say that because that is terrible for US innovation and growth, but this is the current state of the law. Note, though, that if you are American and you're trying to do this, you need to be extremely careful, especially if you have US founders or you touch the US in any way. And you can't just insert a middleman, like have a Cayman entity that sells to a Cayman entity that sells to US buyers, or fire up the VPNs. So I know we have touched on a lot of material today, and I feel like a lot of this is probably new to you. So hope this has been informative and can guide your thinking around some of the issues that are arising with respect to the SEC's regulation of tokens. And I hope it hasn't scared you off, because at the end of the day, as my colleague Jason reassures, people will keep building, and there will ultimately be a path for smart, useful technology. If what you are building is good, useful, and safe, people will want to use it. Lawmakers will want to allow it, and legislators will want to encourage it. Finally, if you want to stay up to date with all things law in the crypto space in the US, I highly recommend this resource. This is a tracker that is maintained by the crypto securities team at my firm. It's super helpful and highly recommend. It's updated very regularly. I'll let you take a photo of that. And then on the last slide, I've also put up my contact details, so you can reach out to me if you have any questions or want to catch me during the break as well. Okay, thanks very much, everyone.